I am Steve Carlson. I'm recording some information for you about breast cancer awareness, and in particular the Minnesota Medical Assistance Breast and Cervical Cancer Program, which in the United States is called the Breast and Cervical Cancer Prevention and Treatment Act. It was passed in 2000 after, in 1990, they started screening, and they ended up with thousands of women who they just had to watch die from breast cancer because they didn't have a treatment program. Now they do, but there's a lot of problems with that treatment program. And so I'm going to give you some information now. I'm the one who recorded a rap video called "Fight Like a Girl, Can't You Feel the Rage." I'm not going to play that over and over for you, but I want you to know why I created that video. And so I'm going to read to you what I've proposed, what we have proposed in a judicial review of what's going on with this. You'll see why I'm talking about throwing Granny off of the cliff. The government doesn't get the drift. The commissioner is spurious. The courts aren't even curious. And these are proposed conclusions of law. It's a lot less exciting, I think, than rap music, but perhaps a lot more important. And here's what I'm proposing that the court say in this case. Based on the facts adopted above and on the memorandum submitted by the appellants and on circumstances tied or cited in the accompanying order, my wife's MABC benefits are hereby ordered to be restored effective immediately. Based on Judge Longfellow's recommendations, the status quo in this contested case is the order to pay benefits on appeal. The court notes that Ramsey County respondents did not appeal the Commissioner's June 8, 2017 decision and must by law abide by it, and they are not. The right to benefits on appeal, which the Commissioner agreed had not been honored, are a hearing requirement for the Minnesota Department of Human Services and may not be disregarded by the Ramsey County or allowed to be disregarded by the MDHS Commissioner, the Department of Human Services Commissioner, Emily Piper, who has taken an oath to uphold the Minnesota law, and therefore recipients' legal right to benefits on appeal, which are a core part of the recommendations that she adopted in 2017. Now this is absolutely needed to make the Minnesota appeal system for women with breast cancer have any chance to comport with the 14th Amendment requirements of due process, procedural due process, elucidated in Goldberg versus Kelly. The MABC benefits for her must be paid until she receives a hearing by a human services judge that is a fair hearing. For that hearing, Ramsey County shall prepare an agency appeal summary and whatever action they propose, for whatever action they propose. The county respondents must provide in their... Alright, I'm going to cut the music now. But according to these proposed recommendations to the court, that Ramsey County, and it's a Ramsey County court, but Ramsey County must prepare an appeal summary for whatever action they propose. The county respondents must provide in their appeal summary, agency appeal summary, the required information on why they took the action that they did and exactly what action were they trying to take. Because what they did, they took someone on this program and they gave them a spend down of about $500 a month that they had to pay in medical bills in their cancer care program before the county and the state of Minnesota would pay anything. Now, it's all supposed to be paid by the county and the state of Minnesota under MABC. So essentially they just took that away, and that's what this complaint is about. And they do this to hundreds, at least hundreds of women in Minnesota alone that they've done this to. Now, why would they do this? Is this a death panel? You know, I think it sounds like it, because you're putting someone at greater risk just because what? to save money. And that's why we don't like socialistic medical care. And people need to really look at this case, I think, when they're thinking about that. Now, this is a miraculous program if you're the right age. If you can complete your treatment before they take it away from you, it's just great. All right, so to continue on, the county would have to restore those benefits immediately. They must, any action they take, they have to inform the recipient of MABC, and they have to prepare a complete appeal summary as to why they did what they did. They can't do it and then blame the recipient, as they've done here, for not telling them why they can't do that. That's just not how the Minnesota state law works. And in that agency summary, according to these recommendations, they must provide the same kind of information for any further action that they might take, except for reversing their actions. Now, their actions were all reversed by the Human Services judge or the commissioner, and she adopted that. And yet she's allowing them to disregard that, and that's where these questions of her oath of office come up. The court also certifies, it is proposed, this contested case as a 42 U.S.C. 1983 case, and recipient has a right, to bring an independent 42 U.S.C. 1983 action to enforce recipient's rights under the Breast and Cervical Cancer Prevention and Treatment Act. And a 1983 case is a constitutional tort. It's saying you committed a tort, a real civil wrong by violating this person's civil rights and violating the Constitution. And those constitutional violations are specifically listed in here. So he also can raise those constitutional tort issues in this judicial review of the agency action, the agency being the Human Services Department. And the judicial review is in Ramsey County District Court. Now, an independent action is not required to, that's what this recommendation says, not required to enforce these federal protected rights in this administrative and judicial appeal process. Because 1983 provides a cause of action and claim of entitlement to enforce that important federal statutory right, including the restoration and reinstatement of her MABC immediately. That cause can be raised in state administrative proceedings. This court and the legislature are subject to its commands, and certainly in a state court under judicial review. Now, the statute in question, I'm going to read a couple statutes, is codified in 42 U.S.C. 1396A, parentheses AA. So any of you that are thinking of getting screened under the federal breast cancer program need to know this law, because it identifies those who, if you do have breast cancer, and unfortunately has happened here, then you can get your treatment paid for. If you're not in there, or if you don't work with your state, you might not get that treatment that you need. Now, and this is combined with another statute called 1396A, but then this is 10, G, and 14. So 14 is in those Roman numerals, okay? And these must be read together. First, this program was intended to benefit the plaintiff. Second, it imposes a congressional mandate on the commissioner rather than mere preference. And three, the plaintiff, and here the appellant's interest in the statute is not vague. Very specific interest in the statute to get that treatment completed, not just started, but completed. That's not what Congress asked for, it was starting the treatment. And I'm citing a case called Bernice Hauser versus the Idaho Department of Health and Welfare, and this is a federal case. So this is not just, I don't think this has ever been interpreted in Minnesota, but in Idaho it's been interpreted by a federal judge, and this is a federal program because it derives from the federal Breast and Cervical Cancer Prevention and Treatment Act. In Minnesota, they codified it to a state program. The legislature passed it They didn't give you anything. They give you about 25% of your treatment dollars. But 75% comes from the federal government. And so you can start to see the rub. It uses Medicaid as a vehicle for a special categorical program. So people who otherwise wouldn't be in Medicaid, but they are low income enough to qualify for the treatment program, the screening program, they then qualify for treatment. And that's paid by Medicaid. So the record shows that recipient, the person who received the MABC benefits, was unlawfully deprived of her MABC benefits beginning on or before November 1st, 2016. That is to say, before her 65th birthday on November 11th of that year. And that on July 1st, 2016, that is to say, after her husband's 65th birthday, that's me, she was assessed a monthly spend down of $433, which is the amount in medical bills she must pay monthly before getting any medical payments under MABC. Because Stephen, the husband or representative, is being required and was required by Ramsey County to contribute his income to pay a spend down before appellant will receive any medical care payments for her continuing cancer care, is continuing, goes about another year. Stephen is an appellant because he has a direct interest in the case, property and other rights and entitlements to vindicate, which would otherwise be decided and binding on him, and he has standing in this contested case. Now, appellant, that's the recipient, the one who's receiving the benefits, argued below and maintains here that respondents, that's Commissioner Emily Piper and the director of the Ramsey County Community Human Services Department, Tina Curry, I believe her name is, and also Ebony Phillips, who's a financial lead worker there, and also Terrell Nelson, who's a caseworker. So when you get cancer, this program intervenes to save your life, and it's a wonderful program. But then they turn you over to the welfare department in your county for the rest of your treatment, and that's where you start to get treated like a welfare patient, when in fact cancer care requires timely, very up-to-date treatment that's going to give you the best odds, the best chances of being it, and it's very successful, but it has to be followed through by bureaucrats who really don't know anything about it. They just see it paying out more money to people, and it's not based on welfare. So it competes with some of the Medicaid things that Obama's been doing, apparently, and people don't want to talk about it. Amy Klobuchar, Betty McCollum, Tina Smith, now she's a senator from Minnesota, they don't want to talk about it. But it does compete because it's the same dollars. If they take you off the program, they don't care what happens to you, but now they have those dollars that they can use and say that it's Donald Trump, that they're fighting against Donald Trump. So what she is maintaining is that the respondents have improperly applied the principles in their policy manual. They got out their policy manual describing eligibility requirements for breast cancer medical assistance, I'll call it, and also eligibility requirements for elderly programs where certain persons acquire an entitlement to some medical assistance based on their attaining age 65 and on their income. And that they improperly applied the MABC statutes, that's Minnesota Statute 256B.057, Subdivision 10, to her case. Why? Because she met the eligibility requirements for the program in A of Subdivision 10 and is thereby entitled by B to, quote, medical assistance limited to services provided during the period that the person receives treatment for breast or cervical cancer, unquote. And that based on facts before the commissioner, she was and in fact continues to be receiving treatment for breast cancer. Although B does refer to an eligible person, she has met those criteria, and the statute makes no reference to losing that eligibility. As appellants maintain in their, can you give me the bottle back? Sorry, there's a noisy bird here. So as appellants maintain in their accompanying memorandum, there is no creeping eligibility, partial eligibility for some participants in NABC or lesser or inferior eligibility in the Breast and Cervical Cancer Prevention and Treatment Act statute passed by Congress. Respondents have shown none. They don't show any, and this court, we're recommending the court say, cannot infer one based only on the chronological age of diverse individuals' cancer treatments begun by each woman at different times in the breast cancer program and the lengths of treatment prescribed by their medical providers. She remains eligible and must have her treatment paid for under her categorical eligibility for Medicaid acquired under Subdivision 10, which she has not lost as a matter of law. Now, number 7, statutory construction. They're construing the statute is a question of law, which an appellate court reviews de novo. So they just apply the law. So this is from Minnesota Supreme Court case 1998 called Brookfield Trade Center versus County of Ramsey. And application of a statute to undisputed facts involves a question of law. The decision of the trial court is not binding on a reviewing court. That's from Minnesota 1996. And this is basically, it's from the Administrative Procedures Act, and it allows even this district court in this case to, under these procedures, to review an administrative agency action that is contested. Here, what's contested is the Minnesota Department of Human Services. Now in this case, what is undisputed is that she has met the statutory requirements provided by Congress. She is in the course of treatment described here, and that treatment was still continuing based on the facts before the Commissioner in DHS, Department of Human Services docket number 185231, and in fact continues today. Therefore, this court is not bound by the decision or action of the Commissioner. Now, respondents argue that a person who ages in treatment during the grant by Congress in the Minnesota legislature of funding for cancer care under SAGE, the Minnesota version of the federal screening program, and the medical assistance breast cancer, and thereafter attains age 65, but still needs the cancer treatment, thereby is deprived of that funding granted by Congress and the legislature. That's what the county is saying, that she's deprived of that, even though it's been granted to her under the conditions she's still in, but she simply attained the age of 65. So they say that she's thereby deprived of that funding granted by Congress and the Minnesota legislature, and that the funding therefore remains with the state. Now I put a footnote in here. The court notes that the funding under this categorical eligibility of breast cancer is received by Minnesota from the United States on a 75 to 25% match, compared to the 50-50 match for needs-based eligibility. In other words, according to the discussion in the Congress, they're going to give a greater amount to fund this treatment. And it would be specified for the treatment of those individuals. And I don't know exactly how the money changes hands, but it's a lot more money. And so that was a footnote that I put in and out. But this language, which strips women of existing eligibility, is not in the statutes. And this court cannot read such language into the legislature's words or the words of Congress. And in fact, the words of Congress in the congressional record presented to this court by the Commissioner ring loud and clear in the opposite direction, showing a clear purpose and intent to provide funding for full, complete, and appropriate treatment for those women, like recipient, who found themselves diagnosed with cancer under the program but not provided with needed funding for cancer treatment for their condition. There is no language to suggest that once granting this treatment funding, Congress then intended to weed the recipients out of the program as their treatment progressed to the stated purpose of healing and rescuing from mortality, but was still not finished. To read this interpretation into the statute, state and federal statutory schemes would be at odds with acceptable medical practices in Minnesota and elsewhere, and does not meet the rational basis test, and no rational basis for this practice has been shown. 10. The court finds that it is not bound by any clear and unambiguous words, this is what the commissioner argues, or language in the text of the statutes, which precludes me from probing into the spirit and purpose of either the congressional or state statutes. And certainly the Minnesota legislature would not be entitled to pass a law in whatever language that would bar the court from inquiring into the spirit and purpose of the congressional act. Respondents have provided no language in the federal statutes that I mentioned, the AAA and the A10G 14 Roman numerals, which is so clear and unambiguous that the court is not allowed to, or in fact is not compelled to consider that spirit and intent. In fact, a federal court from another circuit, John Luster in Hauser, Supra, which I mentioned from Idaho, has examined these two statutes represented in Minnesota Statutes 256B.057, as I mentioned, Subdivision 10, Clauses A and B, and found and compelled a conclusion that the legitimate grants, or legislative grants, fund medical payments during the time the categorical recipient, who's a recipient of Medicaid because she's in the category of having been diagnosed under this program as needing cancer treatment, and as long as she remains in that treatment. This is what the federal judge in Idaho says. Quote, the first federal statute at issue here provides for optional coverage. That means the state can do this program or not. Minnesota did do this program for certain breast or cervical cancer patients. The individuals must have been screened for breast and cervical cancer and must need treatment for breast or cervical cancer. He added emphasis, that's AA. Now the second federal statute at issue here states that Medicaid eligibility for a person who qualifies under the breast and cervical cancer program shall be limited to medical assistance provided during the period in which such individual requires treatment for breast or cervical cancer. And that's Clause B of our law in Minnesota that we've adopted from the Congress. Therefore, says Judge Luster, it can be concluded that the relevant language of the two statutes, when viewed together, provides for Medicaid eligibility for persons who need treatment for breast cancer during the period in which such an individual requires treatment for breast cancer, even if she survives to 65 under her 5-year cancer treatment. Now, 12. The court finds there is no issue whether recipient remains an individual described in 1396 AAA. She's described there. Or the corresponding treatment provision, which she clearly is still in treatment. But the issue is whether equal protection by the U.S. Constitution, the 14th Amendment, demands the government, and we think it shouldn't just be a rational basis here, but it should be a compelling state interest that the state of Minnesota has to show why it needs to throw Granny off the cliff, throw women out of the Medicaid breast cancer treatment program. So, but here the issue is whether that equal protection, which includes both rational basis and the higher level of scrutiny of a compelling state interest, which is for fundamental rights, and we do discuss why it's a fundamental right. But this analysis is of the rational basis. Does it even make sense? Why would Congress pass a law that gives some women that are given treatment, lesser treatment, inferior treatment, and partial treatment? Why would they do that? It's irrational. And the state's arguing, yeah, that's very rational. And we're arguing, no, that's not rational at all. And therefore, it violates the U.S. Constitution. You can't do that. Congress didn't do that, and if they did do that, it would violate the U.S. Constitution, which is the Equal Protection Clause. So, don't want to get too much into that because I'm going to address it right here. So, the issue is whether equal protection demands the government to continue to fund that treatment through the categorical Medicaid program based on breast cancer that she is in. Now clearly she and all the women are similarly situated. That is to say they were all described, even if only initially, and I got another footnote here. Well, here I just say that the women, I don't want to get too technical, so I'm going to ignore that footnote. So they were described even if only initially in the federal statute. And thereafter, they're treated differently. So they're similarly situated because they're all initially begun in this program, but after that, they're treated differently, and therein lies the equal protection rub. Respondents argue that while they admit that the Equal Protection Clause of the 14th Amendment commands that no state shall deny to any person within its jurisdiction the equal protection of the laws, which is essentially a direction that all persons similarly situated should be treated alike, and this is from a U.S. Supreme Court case in 1985. But they argue that equal protection requires that persons similarly be treated alike. Sure, that only invidious discrimination is deemed constitutionally offensive, and this is from Minnesota Supreme Court cases from 2004 and 2005. Respondents argue that appellant cannot show she is part of a class similarly situated to, but treated differently from individuals receiving MABC, just because they're receiving MABC. They're a different class. I can't ask why. So they say that those 65 years of age and older and needing treatment for breast cancer are not similarly situated to individuals younger than 65 years old and otherwise eligible for the MABC program. So they brought up two criteria. They're under 65 and they're eligible. And therefore, it's not wrong that she's not eligible. And these are individuals who are not eligible for Medicare. Okay, so Medicare. There's a footnote on Medicare. On this issue of Medicare, the court notes that Medicaid and Medicare are not mutually exclusive. In fact, the government seems to suggest the recipient is in fact eligible for Medicaid. That is to say, elderly persons Medicaid, and that they think this is clearly and unambiguously a creditable insurance for cancer care. But the issue is, what did Congress intend? Did they intend that the 80% paid by Medicare, so now they're down to 80%, short of the 100% paid under the categorical benefits, should substitute for some women in the program and still fulfill their promise of, Congress's promise of funding cancer treatment? That's dubious. And I think I'm going to have to start to break this up. I'm going to stop in about 5 minutes and go into a second video here. But it's dubious that Congress only wanted to pay 80% for just some of the women in the cancer care funding that they did fund. Now further, the record shows that appellants cannot make the $433 monthly or more in medical payments, and even if they did, it would not be the categorical Medicaid benefits. And the question is, what did Congress intend to do? Did they intend to leave these women in the deadly crack they just rescued them from by funding their cancer treatment? Appellants argue, and the court agrees, that as an initial requirement, Medicare and age 65 were used. But those women that were excluded were left in a deadly crack as well. They were diagnosed with cancer and they still are not getting cancer care dollars from this treatment program. And this program is the gold standard. It's the only one that really fights back against breast cancer. Other people still fight back, but there is no program that does that. And that's what this program does. It's a great program. I discovered when I was working at the American Cancer Society. So, but that issue is not before the court, whether Medicare fulfills the categorical entitlements of a recipient of Medicaid, even one who after eligibility attains age 65 during treatment. Further, in this case, Medicaid does remain a payer of last resort if the women remain in the categorical benefit, which greatly reduced the cost of the Medicaid program to about 20%, while maintaining the integrity of the purpose and also the purpose of Congress, and also the efficiency, economy, and quality of medical care provided through the Breast and Cervical Cancer Early, this is a Prevention and Treatment Act. So that's a little aside about Medicare, just because it's raised as getting the state off the hook on the equal protection, that they're not similarly situated. Well, of course, they remain similarly situated. So by virtue of being age 65, the state argues, appellant and others over the age of 65 who previously would have qualified for MABC, and again, but here all women similarly situated to recipient were qualified for MABC, and that is the equal protection issue. So they would have access to Medicaid. Now, in fact, appellant is also eligible for, they argue, for the elderly people's program. Therefore, they argue the two classes are not similarly situated, unquote. Well, the court says, while difficult to comprehend, this argument, fairly construed, seems to be that recipient was once similarly situated with individuals receiving MABC because she was admittedly an individual receiving MABC. And as of November 1st, 2016, for sure, she was not such an individual since she was deprived by the county of her MABC while 64 years old. Her medical assistance was reinstated November 1st, and it was reinstated as MA with a spend-out, which is not MABC. It doesn't have a spend-out. But this begs the question, why exactly is it that she was no longer a member of this classification on November 1st? She was not 65 until November 11th, and on November 1st, she received no Medicare. And this shows the state did not apply equal protection as a matter of factual record when they did this to her. Because by all means she was meant by the federal law to be a member of that same similarly situated class of women, but because they are 64 and meet all the other requirements, she didn't have Medicare for instance, are receiving MABC. 14. But even supposing respondents had waited until November 11th, 2016, and then put recipient in this supposed class of those who are not receiving MABC, cleanly, put it in clean without all this stuff that you find out it was really a mess. But let's suppose they just did that right, and they posed that to us, and we wanted to challenge that. And they told us the law and why they were doing it, and we were able to say, well, no, you're wrong. But they didn't do that. But even suppose they had. They put her in the supposed class of those who are not receiving MABC because but now, because she attained age 65, it's clearly wrong to argue that the courts could not even question whether to take her MABC on that day also violated her equal protection rights, because she still remains in the class of women who have been determined eligible for and have received MABC under the state plan as part of the federal categorical Medicaid program of Breast and Cervical Cancer Prevention and Treatment Act, part of the Mortality Reduction Act, by the way. And now she's become part of that special subset of women who did receive MABC because they were in cancer treatment and they are still in cancer treatment, but now the government has, for some reason, ceased to fund that treatment. I'm talking about state government. We don't think that's what Congress intended to do. Now these women are the victim of a creeping eligibility standard, an eligibility standard that moves. And it is a result of things they can't control. They age, which is undeniably a fundamental right. It's something the government cannot be permitted to reach out and impose some penalty or treat people differently because of, just because they aged while receiving that benefit. And so the state should show a compelling interest for its conduct. But more importantly, they are in cancer treatment. Another important characteristic they share with those the government admits are entitled to equal protection. And their treatment is no different from those still protected. But their treatment started at a certain time. And the statute makes no distinction between any times of beginning treatment, provided it started after the effective date of the legislation. And yet, here their time of commencing treatment is supposedly a ground for treating them differently. And so is the length of their treatment, depending on when the treatment starts in relation to the expected attainment of age 65. That's clearly a purpose of the Federal Breast and Cervical Cancer Protection Treatment Act. Now, if the treatment is 1 year, and the woman remains in the protected class, so a recipient who was 62 at the time would easily have cleared that hurdle. But because the treatment she is prescribed is over 5 years, though, the commissioner claims she is no longer protected by the Equal Protection Clause. So this is on the provider. Had the provider known, and if they were capable by current medicine, they could have chosen a shorter treatment, right? And it would have been paid for. So here perhaps the provider should have been forced by law to substitute chemotherapy for hormone treatment. Well, in fact, this provider substituted hormone treatment for chemotherapy. But this clearly would get this court, this is the court writing, as we propose they should write, and the commissioner into second-guessing medical decisions in cancer treatment and deciding on a case-by-case basis just which treatments for which patients are allowed to be funded by the act, the federal act. And this most certainly the Congress and the Minnesota legislature did not do. So this distinction, this creeping eligibility provision must fall entirely. It does not pass even a rational basis test under any hypothetical circumstances. And it takes similarly situated women, and now the government argues they're not similarly situated after all, in some material respects, because of this artifact of the will of the Commissioner of the Department of Human Services. Now, in fact, Congress has made no such distinctions regarding time within the effective date of the BCCPTA legislation at which the patient commenced cancer treatment. But if they had, it would be more clear to respondents that it would be subject to an equal protection analysis. They would have to show that even subject to a deferential standard, for which the Commissioner cites Minnesota Supreme Court 2008 case to argue that even a hypothetical set of facts could provide a rational basis for the challenge classification. Well, I'm going to end this video here and pick it up in the second one that's going to focus on what's the interest of the state in keeping the money, in maintaining the fiscal integrity of welfare, as opposed to this woman's right to receive her promised cancer treatment to get paid for it. And how is the court to balance this? So again, this is Steve Carlson. Since I got you here, I'm just going to play the music again in the background as I take this out. Again, to sum up, this is a woman who has been granted categorical Medicaid status in order for the Congress to pay for her treatment. That's where they put the money. That's where they thought it would be best to administer this program, which is a federal program, and for which they give 75 cents out of every dollar to the state of Minnesota to fund. And now the state is turning around and they're interpreting just a single clause that's actually a single provision in a single clause that's an initial eligibility. And so they're saying that this clause says that she can't get equal protection of the law to see if that's right to pull her out of treatment at age 65. That she's been given, she's still in that treatment. It is a life-saving program. But, and when this program was passed, I read the congressional record, and a number of the members of Congress who were women, and there weren't very many women in the Congress, but a number of them had breast cancer. And they passed this law because they say after going through this, I don't want to see any woman that gets diagnosed and then cannot get her treatment paid for. And that's why we're passing this act. They didn't say we're going to treat some people differently. We're going to give it to them, then we're going to go out among them and say, oh, got to pull you off the program. Because you started your treatment at this time, and it's going on for 5 years. Time's up. And by the way, when Judge Lester, in that Idaho case, which is just a groundbreaking case, it's a wonderful case, very rational, professional man Judge Lester is. He's like, I guess, one of the big federal judges in the state of Idaho. He wrote this case, and he saved, a lot of lives by allowing people to give them this hormone therapy. What the hormone therapy does, it cuts in half their risk of relapse, that cancer is going to come back. And you hear so many stories about people who get cancer. They get treatment, and of course after the treatment, cancer's gone, right? But it can return, and that's called a relapse. So they're in remission, and then at a certain point, if you get to 5 years of remission, then you're cancer-free. And you hear that a lot. Now, we're fighting against cancer. There's a war on cancer, Joe Biden and Amy Klobuchar. There is a war on cancer. And we're fighting. And I work with the American Cancer Society as a resource specialist. And I identify this program as a very key program. But it's for poor women. It's for women that are low income. It's not for, people who have these Cadillac plans. Hopefully, if they act quickly and they're blessed by God and they get the Cadillac plan to get that treatment, they're going to make it. Because God's going to give them their life. And we believe that's what's happened in this case. We don't put our faith in the government for obvious reasons. I'm going to tell you more on another, I'll tell you more in the next recording. Thank you.